Well, good morning, everybody. Thanks for joining in today. I'm Ricardo Maxit, Director of Copernico Capital Partners, and I want to welcome you to our Copernico webinar on Venezuela statute of limitations, prescriptions, and other legal considerations. This event is part of a series of webinars. You may have attended some of those in the past. We usually discuss the present situation in Venezuela, including economy, politics, and of course, the situation of the debt issued by the Republic and also by PDVSA. Today, we are very honored to have with us Lee Bucay. I'm going to read briefly a brief bio because it's a quite long one, but I have a short version here. Lee Bucay retired in 2019 after 43 years in private legal practice. For much of his career, Lee specialized in sovereign debt management projects and has worked on over 2,000 sovereign debt restructurings. Lee led the international legal teams advising the Hellenic Republic, that's Greece, and the Republic of Iraq in their debt restructurings, the two largest sovereign debt workouts in history. Lee is the author of 2 books in the field of international law and over 40 scholarly papers on sovereign debt matters. He holds academic appointments at several universities in the United States and Europe. Lee is going to provide us with his thoughts on some key legal issues that affect or may affect the Venezuelan bonds. And we'd like you to send questions throughout the presentation. After Mr. Bucay comments, Jorge Piedrahita, who most of you know and is our external advisor on Venezuela, will ask a few questions. He will select them from the audience. So without further delay, Lee, the floor is yours. Thank you very much.
Thank you. And ladies and gentlemen, wonderful to be with you this morning. I've been asked to talk to you about several legal issues that bear upon the debt situation in Venezuela. So this is something of a mixed bag, but let me begin with prescription and statute of limitations. First, prescription. Prescription clauses in sovereign bonds have a long history. They go well back to the period before ownership of sovereign bonds was recorded in any electronic way. And the concern was, in those days, you literally physically clipped your coupon for an interest payment and brought it to the paying agent and were paid. The concern back then was what happens if the proverbial Belgian dentist dies and the bond is lost? Must the fiscal agent hang on to the funds that had been given to it to pay the coupon? Must they hang on to it forever? Prescription clauses were originally designed to solve that problem. They said that after a certain period of time, the fiscal agent is entitled to return any unclaimed monies to the issuer, and thereafter the bondholder looks to the issuer for payment. The clauses have morphed over time, and you now have prescription clauses that purport to say that payments themselves become void unless they are presented within a certain period of time. That is how the clause is worded in Republic of Venezuela bonds. It says that unless presented for payment within 10 years for a claim of principal and 3 years for a claim of interest, a payment becomes void. Unless presented for payment within that period after the relevant date. That's the definition that becomes important. Relevant date is defined as the later of the date on which the payment was scheduled to fall due and the date on which the fiscal agent has been placed in funds to pay that amount. Well, the fiscal agents under Republic bonds stopped being put in funds to pay principal and interest back in the fall of 2017. So the relevant date hasn't occurred, and therefore the prescription period in Republic bonds has not yet begun to run. There was a flurry of concern about this back in 2020, and some press reports saying that prescription period was running on interest payments. All of that was false. The prescription period hasn't begun to run. Moreover, the interim government of Juan Guaido put out a statement in September of 2020 confirming that that is how they understand the prescription clauses to operate. So that's the good news of the morning, that prescription is not a problem. Statute of limitations, however, is another issue, a quite separate issue. Statute of limitations are statutory provisions, jurisdiction by jurisdictions, which prescribe the period during which a claim must be brought to a court for enforcement, or else the claimant loses its ability to enforce in those courts. The limitations period will differ from jurisdictions to jurisdiction, and they will differ within a jurisdiction depending on the type of claim. For debt claims, such as those under Republic and PDVSA bonds, the statute of limitations in New York and in England is 6 years. Republic and PDVSA bonds began to fall into default in the fall of 2017. So add 6 years to that, and it brings you to the fall of next year. So we are beginning to approach the period in which a statute of limitations is a concern for bondholders. It is possible for bondholders and the issuer of the bonds to extend the statute of limitations period, in the jargon, to toll the statute of limitations by written agreement. And in that September 2020 statement of the Guaido administration, the Guaido folks said that if people begin to bump up against statute of limitations concerns, they should approach the Guaido administration, and they will entertain proposals to extend, to toll the statute of limitations. If the tolling doesn't happen, then I would expect, as we move into next year, you're going to see more lawsuits filed, not because the bondholders are particularly litigious, but rather because they feel that they must do that to preserve their claim. And the way it works is for a bond that has not been accelerated, as a payment of interest or principal falls due, you begin to run the 6 years from that due date for that payment. If a bond has been accelerated, then it is 6 years from the date of acceleration. I cannot give you any consistent answer to what happens in a debt restructuring to claims for which the statute of limitations has run. The history is checkered. Some countries, Iraq being a very good example, elected not to filter eligible claims in the debt restructuring through a statute of limitations. Saddam began to default in August of 1990, when the Security Council imposed sanctions on his regime as a result of the invasion of Kuwait. The debt restructuring didn't occur until 2005. So the statute of limitations on hundreds of those claims had run. And Iraq theoretically could have said, they will not treat as eligible in the debt restructuring any claim for which the statute is run. They did not say that. And in my view, that was the right decision. Liberia, a country that had claims going back, defaulted claims back 30 years, similarly did not attempt to filter them with a statute of limitations. Other countries have taken a different view. Perhaps the most recent and prominent was Argentina's debt restructuring in 2020, where the authorities took the view that if they allowed time-barred claims, that is, claims for which the statute had run, into the debt restructuring, that they could theoretically expose themselves to personal liability. Final comment. There is a difference between the operation of a prescription clause and a statute of limitations. Where the prescription clause is worded, as it is in Republic of Venezuela bonds, to say that a claim shall become void unless presented, the claim will entirely disappear. The running of a statute of limitations on a claim does not void the claim. The claim remains legally viable. For example, if the bondholder had an opportunity to set off its claim against an asset of the issuer, it would be entitled to do that. And theoretically, sovereign issuers should continue to be showing time-barred claims on their debt records, although I sometimes wonder whether that is observed with any great degree of scrupulousness. Final comment on this, because I know it will be on your minds. If bondholders wished to toll statute of limitations on Republic of Venezuela bonds, to whom should they speak? Under current US law, the Guaido administration is the only recognized government of Venezuela, and therefore the only one entitled in US courts to represent the Republic. So under the current situation, certainly the signature of the Guaido administration would be necessary. I could easily see how bondholders might also say, we'd like the Maduro administration also to sign that piece of paper, and whether both administrations would be prepared to do it, I just don't know. The second topic I've been asked to spend a few moments on is US executive power as it relates to sovereign debt workouts. The restructuring of Venezuela's debt, legacy debt, by that I mean Chavez Maduro era debt, the restructuring of that debt, when and if it comes, is going to be particularly complicated for several reasons. First, as you well know, the economy has been decimated by years, decades of mismanagement and corruption. It will not be an easy task to restore that economy to a functioning position very quickly. Second, there is an unusually diverse group of creditors in Venezuela. These are not just commercial banks, as we saw back in the 1980s, nor are they just bondholders, as we have seen in the debt restructurings, sovereign debt restructurings of this century. In Venezuela's case, as in Iraq's case, the claimants include unpaid suppliers. They include arbitration award holders for people who had their investments expropriated. They include promissory note holders. They include people who simply had FX deposits locked up in Venezuela now for decades. We have no institutional method within the sovereign debt restructuring community for coordinating a diverse group of creditors of that kind. The institutions we have implemented in this century, like collective action clauses, will operate only within one type of creditor, in that case, bondholders. And they can be very useful in facilitating a coordinated debt restructuring among bondholders, but they do not, in their present form, at least, reach across creditor groups, so could not bring in, for example, syndicated loans, much less unpaid suppliers, much less arbitration award holders, and so forth. The final complicating factor is that this thing has gone on so long. Lawsuits have begun, attachments against assets, principally Citco, have taken place or are pending, awaiting a relaxation of the US sanctions if that is to occur. The question then that has been asked, and it has been asked as far back as 2017, is would the US government, in particular the executive branch of the US government, be prepared to use its authority in some fashion to facilitate a restructuring of Venezuela's debt? Now, the power of the US president is very considerable in these situations. Under our Constitution, the executive branch has the principal responsibility for the conduct of foreign affairs. And were the president to say that a matter is a matter of emergency and great concern to the foreign affairs of the United States, that triggers his authority to take action in that area. President Biden did so yesterday, interestingly, saying that Americans held hostage abroad is a matter of national emergency. There are a couple of very interesting precedents for how actions could be taken. And by the way, the sanctions imposed on the Maduro regime by the US Treasury, the Office of Foreign Asset Controls, OFAC, are an example of how the executive's authority can be implemented in practice. Those sanctions, as you know, block any efforts to seize Venezuelan property in this country by private litigants. And they have been in place going back all the way to August of 2017. A couple of precedents that people talk about. One is Iraq. Saddam Hussein was asked to leave in May of 2003. That same month, the United Nations Security Council passed a resolution that encouraged the new government of Iraq, the post-Saddam government, and Iraq's legacy creditors, holders of claims against that arose during the Saddam regime, to negotiate and settle those claims. This was thought to be an essential prerequisite to the orderly reconstruction of Iraq, something that the United States and its coalition partners were committed to. As part of that Security Council resolution, and this is the one and only time I'm aware that this has happened, the Security Council clothed Iraqi assets worldwide with a special immunity from any form of judicial process, in effect, putting them off limits to any litigating creditor of the Saddam era that wanted to recover its claim through judicial remedies. They were not prevented from bringing their lawsuits, but they were prevented from satisfying any judgments by attaching assets. And because this was an action taken by the Security Council under its so-called peace and security powers, it was mandatory on all member countries to implement it. It was implemented in the United States, and I think that action significantly improved or significantly facilitated the restructuring of the Saddam era debt stock, which occurred between 2005 and 2008. 13,112 separate claims were all restructured on pretty savage terms. The net present value loss for the claimants was 89.75%. So it was a breathtaking debt restructuring. There have been those who have said, not just in the context of Venezuela, but in other sovereign debt workouts, that perhaps the Security Council would wish to get involved again. I think it is extremely unlikely that that would happen, and particularly for Venezuela. Remember that Russia sits as a permanent member of the Security Council and so enjoys a veto over any action of that kind. Even without a Security Council resolution, however, the President of the United States enjoys the power, if he or she wishes to use it, to immunize assets from attachments in the context of litigation. The second precedent that people talk about is Iran. Following the Iran hostage crisis that began in November of 1979. The way that situation ended, by the time it ended in 1981, more than 400 lawsuits had been brought against Iranian public sector borrowers in US courts, and there were many attachments that accompanied those lawsuits. The settlement, embodied in something called the Algiers Accords of 1980, provided that the hostages would be released if the lawsuits against Iran in US courts were lifted, the attachments voided, and both the claimants and the money sent to a special ad hoc arbitration group in The Hague, known as the United States-Iran Arbitration Tribunal. 30 minutes after President Reagan was inaugurated in 1981, the hostages were released, and President Reagan used his executive power to implement the Algiers Accords. He was sued for it. One of the claimants, a construction group called Dames and Moore, sued the president and said that these actions, the voiding of the lawsuits and attachments and the transfer of everyone to The Hague, were beyond his constitutional powers. The Supreme Court upheld President Reagan in that instance and said that his powers really were quite broad. How might they be used in Venezuela? Well, continuing some sort of protection for Venezuelan assets as an inducement for claimants to come to a negotiated solution would be one way to do it. Theoretically, the president could try to retrofit some sort of collective action voting mechanism on this diverse debt stock. That is something that the Greek government did back in 2012 for the debt instruments that were governed by Greek law. But let's be honest about it. The US executive branch is notoriously reluctant to use this power. It has the power, and it is most recently being debated in the context of the frozen Russian assets and whether the president has the ability to confiscate those assets, not just freeze them. But the power is there. But the US government has, going all the way back to 1982, always taken the position that it prefers to see negotiated resolutions of sovereign debt problems, not resolutions that are forced either by domestic law of the sovereign issuer or by changes to US law. The final topic I've been asked to talk to you about is a question that is known as odious debt. And allow me to be a little professorial here. Under public international law, there is a doctrine called state succession. What it says is that a state, a government within a state, succeeds to, inherits both the rights and the obligations of its predecessor governments or sometimes states. It does not matter how different in political philosophy the two governments may have been. So the Bolsheviks take over from the Tsar of Russia in 1917. As a matter of international law, the Bolsheviks were held to be responsible for the Tsar's debts. Napoleon Bonaparte takes over the Bourbon monarchy and acknowledges responsibility for the debts of the monarchy. Mr. Biden takes over from Mr. Trump and is obliged, as a matter of international law, to recognize the debts that had been incurred prior to Mr. Biden's inauguration by the United States. The same will be true in Venezuela. So if you have a successor administration in Venezuela, no matter how they feel about Chavez and Maduro, no matter how distasteful they may find the debts incurred by Chavez and Maduro, they, as a matter of law, will be responsible for those debts. There are a couple of exceptions to this very strict rule. One of them, articulated in this form for the first time in 1927, said that if a successor government takes over from a dictatorial regime, the debts incurred by that dictatorial regime that were not used for the benefit of the citizens of that country, and where that fact was known or should have been known by the lenders, those debts are deemed odious and may be repudiated by the incoming regime on that basis. This principle has never achieved the status of being a doctrine of international law. It is simply too difficult a principle to administer, largely for definitional reasons. What, after all, is an odious debt? Is it any debt incurred by an odious regime? Question mark. And who gets to decide whether the regime is odious? This issue came up very starkly in 2003 in the case of Iraq. Saddam met most people's definition of an odious dictator, and there were those within the administration of George Bush the Younger who felt very strongly that anyone who had lent money to Saddam Hussein should have known that that money would not be collectible if the Saddam regime were overthrown. And so in a curious way, you had officials of the US government, the White House, strongly urging that the doctrine of odious debt be applied to cancel, repudiate debts of the Saddam regime back in 2003. That's not how it came out. The incoming Iraqi government very scrupulously did not base its request for debt relief from its bilateral and commercial creditors on the odious character of the underlying claims. They could have, but they didn't. Instead, they based their claim on the need for Iraq's reconstruction and the extraordinary geopolitical challenges that an unstable Iraq posed. But you will hear this at such time as the Maduro regime cedes power, willingly or unwillingly. I expect you will hear people say that the legacy debt stock of Chavez and Maduro ought to be branded odious. Certainly some of the NGOs will take that position. I think it unlikely, however, that a US or English court under the current state of the law will recognize odiousness as a defense against a claim in the US or English courts. There are components of odiousness, like corruption, in the incurrence of the debt that can be raised as a defense in an English or US court. It is right now happening in the context of Mozambique. You remember the famous tuna boat loans. They are being challenged, but based on corruption and other doctrines that are familiar to Anglo-American law. Jorge, I'm going to stop there, my friend, and allow you or our friends to ask any questions.
Thank you very much, Lee. It's a real treat to have you at this event. One question is, let's say we have a series of bonds where all bondholders have remained passive. In other words, they have not signed a tolling agreement or accessed the courts. The 6 years have passed for all coupons, principal and of course interest. And at that point, as you described, those bondholders have no remedies. And then, let's say, the Republic of Venezuela puts forward a restructuring offer under the harsh terms that you described for Iraq, let's say a principal haircut of 90%. The question is, what can those bondholders realistically do other than, if they are offered such restructuring terms, because that's a question mark, and as you well described, some countries may or may not make that offer. But is there anything that those bondholders can realistically do other than just accept the restructuring terms?
Yes, if the statute has completely run on the claim, so it's not just the coupons, but the principal maturity happened 6 years ago, and there's been no tolling agreement. One thing bondholders do in these situations is look to see whether the sovereign issuer may have inadvertently restarted the statute of limitations. Under our law, if a debtor acknowledges a debt in writing, that will restart the statute of limitations. And I'll give you the law school example that we were always taught. You buy a refrigerator from Sears Roebuck and it costs $1,000 and you don't pay it. And Sears Roebuck sells that claim to a debt collector, and the debt collector comes after you years later, after the statute is run, and says, Jorge, you owe Sears Roebuck $1,000 and you didn't pay it. And they hope that you will write back and, no, they write to you and say, you owe Sears Roebuck $2,000 and you didn't pay it. They hope you will write back and say, I don't owe $2,000, I owe them $1,000, so go away. well, having done that, they've restarted the statute of limitations. And you've seen this in the Argentine litigation, where people go over debt records that the Argentines have published from time to time, which continue to show these debts for which the statute has run as live claims, which they are, for the reason I mentioned. The running of the statute of limitations does not void the claim. So that's one thing that people typically do, but they will also try to use their public relations power for so long as the debt remains in default. It is potentially the subject of uncomfortable headlines for the sovereign. And if the sovereign wishes to turn over a new leaf, return to the markets, etc., they will not want those headlines. I cannot tell you that that public relations factor alone will get a sovereign to acknowledge these debts. But as I say, there are some prominent examples in the last 20 years of countries that have recognized claims and brought them into a debt restructuring, even though the statute has run. And the reason, by the way, is that when a country goes into default, typically it will say to all of the claimants, calm down, everyone. There is no need to run to the courthouse. Give us a little time. We're going to work this out. We haven't forgotten you, et cetera, et cetera, et cetera. 6 years later, if there hasn't been a resolution, it looks a little harsh for the sovereign to come back to the same people that it said, please don't sue us, and say to them, you didn't sue us, and therefore you are consigned to the outer darkness of perpetual payment default. So that was one of the factors that influenced Iraq and Liberia, for example. So, but there it is.
So would it be fair to state that from an issuer's perspective, it makes sense to let the statute of limitations pass and then have an upper hand when the restructuring comes?
In one sense, yes, but in a much more profound sense, no. Look, there are a couple of things the issuer should be thinking about. The first is, if you decline to toll, you're going to bring down on your head hundreds, maybe thousands of lawsuits. Do you have the resources to defend those lawsuits, or are you going to let default judgments be taken against you? Second, there is always the possibility that some plaintiffs' lawyers will bring class actions. We have this mechanism in our federal rules of civil procedure where similarly situated claimants that are too numerous to bring individual lawsuits can be brought, a lawsuit can be brought on behalf of the class. Such a class lawsuit was in fact filed in October, I think, of 2020 against Venezuela. I don't know where it stands today, but I would expect to see that. Class actions were also filed against Argentina in the run-up to the settlement with President Macri back in 2016. So I would not encourage a sovereign to simply lie low in the tall grass and hope that the statute will run. It's likely to be more of a nosebleed for the sovereign than signing a tolling agreement.
Thank you. So we have several questions from the audience. One of those questions, and I think you alluded to it briefly during your comments, is who gets to determine in the context of odious debt that the proceeds have not been used for the benefit of the population?
Well, if a sovereign were to try to run odious debts as a defense, a legal defense in a claim, it is the judge who would have to make that decision. But the threshold issue for an American or English judge is, does Anglo-American law recognize odiousness as a basis for a defense? And I think under the current state of the law, the answer is no. There are components of odiousness, the principal one being corruption in the incurrence of the debt. If the sovereign can show that the creditor colluded with government officials in a corrupt issuance of the debt, that could be a defense. But odiousness as such has not reached the level in international law of being a recognized doctrine, and therefore would not, I think, be incorporated into Anglo-American law as a defense.
Okay. I also have a question which is not on the list of subjects you touched based upon, but I think it's very relevant for some institutional investors that have been somewhat complaining about the trading ban or the so-called trading ban on the Venezuelan and PDVSA bonds. And the question is, whether is it possible for investors to challenge such ban and the asset protection measures implemented by OFAC, and if so, do they have any chance of success doing so?
Yeah, as I mentioned, the executive branch's powers in this area are quite broad, and the Supreme Court has upheld the president's power to freeze the assets of a foreign country in order to achieve diplomatic, geopolitical objectives of the United States. I would think it unlikely that a legal challenge against OFAC's sanctions, including the restriction on trading, would prosper. That said, OFAC's policy in respect of trading of debt obligations of a sanctioned country has not been consistent over the years. There are some sanctioned countries, North Korea, for example, that OFAC took the position those claims could not be traded. But just cast your mind back earlier this year, the Russian sanctions, when they were first put in place, did not prohibit trading by American holders of Russian debt instruments. And even the Venezuelan sanctions still permit American holders to sell abroad. One of the more infuriating things about OFAC over the years has been their unwillingness to confide the rationale for some of their sanctions. And the trading restriction in both Venezuela and in other countries has always been one that baffled certain members of the commercial community. After all, how does the trading of a legacy debt instrument issued years, in some cases decades ago, how could that be said to benefit the regime that's currently in power and against which the sanctions are intended to operate? The best I was able to determine back when the trading restriction was put in place is that the US Treasury feared that Venezuelan insiders owned positions in Venezuelan and PDVSA bonds that were held by American custodians. And so they cast a very broad net to try to keep them locked up in those positions. But of course, the net had a large hole insofar as it did permit sales abroad. But to my knowledge, OFAC has never said, yes, that was what we were intending to achieve with this. I do know that almost from the moment the trading restriction was put in place, bondholders have lobbied US Treasury to relax it, but at least to date, those efforts have been unavailing.
Okay. There are, other questions not necessarily related to some of the topics you touch upon, but I think this one, it's kind of general and probably, briefly you can talk a little bit about it, which is you have put together papers over the years with many different ideas on how to approach this massive restructuring problem that Venezuela and PDVSA will have in the future. And one of the questions from the audience is many ideas have been put forward so far. Any of that is the most realistic or has the biggest chance of success from those? And I know you probably have a very strong opinion on, what could be done very, very briefly.
Yeah, the Venezuelan situation is complicated by the fact that first, Venezuela has significant assets in the United States, the Citgo empire. But moreover, unlike really any country we've seen since Mexico in the 1980s, Venezuela, pre-sanctions, had commercial contacts with the United States that were very extensive. The United States imported 7% of its oil from Venezuela. That commercial activity is, for the plaintiff's bar, a very attractive target. And therefore, persuading this very diverse group of creditors to join a debt restructuring for Venezuela, even under a new regime that is more politically palatable to the international community and to the investor community, persuading them all to join is going to be a difficult task. And without the ability to use things like collective action clauses across the diversity of that creditor group, it will be even more difficult. So the question then comes, is there any technique that one could use that would encourage everyone? Because unless everyone comes along, the holdouts, whatever their motivation for holding out, the holdouts represent not just a threat to the Venezuelan recovery because of their ability to interfere with Venezuela's oil sales post-sanctions, they also represent a threat, as we have seen in Argentina, to the creditors that elect to participate in the debt restructuring. Remember that it was holdout creditors in Argentina who obtained those injunctions based on the pari passu clause that caused the Argentine government to cease to pay its exchange bonds back in 2012. So holdouts represent a kind of a universal threat. And I think there will be strong motivations to find ways of, if not encouraging holdouts to come along, at least to neutralizing the legal threat they might pose to Venezuela and the participating creditors post-restructuring. One of those techniques, and the one for which we have the largest number of precedents, would be the US president to immunize from attachment Venezuelan assets to prevent their seizure by private litigants. That is something that was done in Iraq. And even after the Security Council resolution expired in Iraq in 2011, President Obama continued those protections in the United States in order to allow the restructuring to be completed. So that, if I had to handicap it, I would think that's the most likely step that might be taken, assuming that the US president approves of whatever political change happens in Venezuela.
So basically what you describe is that holdouts, whatever their motivation, and through the access to courts, get some sort of seniority in the whole affair. And as such, then they are a threat to an orderly process, which is what you are aiming to have.
Yeah, let me just put a little point on that. Transforming oneself from a creditor into the exalted state of judgment creditor by itself conveys no legal seniority. A judgment creditor is in a position to begin enforcement, attaching assets and causing trouble. And to that extent, in a practical sense, it has a degree of seniority. If you go back to July 1 of 2019, the Guaido administration put out a policy statement about its approach to what it then thought was the coming debt restructuring, in which it said that no preference in a debt restructuring will be given to a judgment creditor as opposed to a creditor that had not pursued legal remedies. And that follows the pattern of Iraq. There were about 8 billion judgment creditors caught up in the Iraq affair. They all got exactly the same terms as those who did not receive judgments.
Thank you. And we are just coming to an end, so this will be the final question. And I do apologize to the audience because I do know there are actually quite a few more questions that remain unanswered. But this question relates to more recent events, which, as you know, there has been rumors and lobbying about having Chevron and others restarting operations in Venezuela, negotiating with the Maduro government, putting some working capital and increasing oil production so that it can be sold into the US and Europe. And this is in the context of a major humanitarian crisis as we have in Venezuela. Now, some bondholders have speculated that some of those payments might be used to pay bondholders. In your view, and have my own view, but that's not why people are hearing this call. But in your view, is that a realistic expectation?
Well, a couple of thoughts. First, I have long thought that Mr. Biden would look for some basis on which to relax sanctions because of the humanitarian crisis. Sanctions work best if they produce a quick regime change or change of policy. They are very worrisome if they're in place for a long period of time because they wind up aggravating the humanitarian suffering of the debtor country. And that's the situation we're in now. So I have long thought that Mr. Biden would look for a basis. I think what has happened in Ukraine and the oil shock that has followed has, if anything, stimulated that sentiment in Mr. Biden's breast, that he would like to see some resolution in Venezuela that would permit Venezuela to begin shipping oil again to the United States. That will help relieve some of the pressure, but he won't do that unless Mr. Maduro is prepared to make commitments that Biden feels are credible to free and fair elections and so forth. And in any event, this close to the midterm elections in this country, I'm not sure he will do anything until then. To the extent, however, that oil can be sold again into the United States and produces cash recoveries for the Maduro regime, I think it unlikely they would use any portion of that money to pay legacy bondholders absent a general settlement with those bondholders. All you would do if you permitted partial payments is drive up the secondary market price of those bonds, making it more expensive to restructure them when the time comes. Would they be prepared to use some of those revenues in the context of a general restructuring? Answer, probably yes. But it would require Mr. Biden not only to relax the sanctions on the importation of Venezuelan oil, it would require him to relax the sanctions that have effectively prevented a restructuring of Venezuelan debt since August of 2017.
Perfect. Well, we have come to an end of this event. On behalf of Copernico, I would like to thank Lee for your time and your comments. A lot of clarity. We covered actually a lot of topics, and we do hope that we all learned quite a bit from this process. We have had over 100 participants, and we will also share this event with other people that didn't have the ability to get connected at this particular time. But in any case, thank you very much, Lee, and thank you very much to all participants. Have a good day, everybody.
Thank you.